Good morning or good afternoon. Welcome back to this month's animation. We've covered this topic at this month's blog post, but considering that it is an important update, we decided we will be covering the board's updates on how to deal with the C-8.bs moving forward in our animation this month as well. So if you ever dealt with Form C-8.b, or what the board likes to call the notice of objection to a payment of a bill for treatment provided, you know how annoying it can be. A small misstep can lead to outright denials costing thousands of dollars. Now, the New York Workers' Compensation Board has updated the form, and while these changes are designed to improve clarity and compliance, they also mean more responsibility on your end as carriers and or self-insured employers. Here's what you need to know and how to handle it effectively. So the biggest change is in section C, where you have to state your reasons for objection. Now you know that the form has from 1 to 11 certain boxes you should check. However, now on top of that, you have to explain your reasoning in a box 12 why you objected to the medical bill. Now, if you check the MTG related boxes, which is from 13 to 19, the board now requires from you to provide a detailed explanation in box 20, including the MTG reference codes. A simple not consistent with the MTG is no longer enough. The board expects a clear, narrative explanation referencing specific facts like dates, injury sites, and treatment contexts. Why are you denying the bill? Without this level of detail, your form might be denied as incomplete or legally defective. There are some updates, such as the certification section, where it has been updated to comply with the 12 NYCRR, Section 325, 1.25 C1. Now you must certify that the bill denial notice was sent to the medical provider, to the claimant's attorney, if there's any, and to the board. Failing to notify all parties could lead to dispute over proper service of or timeliness and can be, again, resulted into the denial of the C-8.bs due to being legally ineffective. The board's updated paper form is available on their website, and starting from January 5, 2026, older versions will not be accepted anymore. Using outdated forms could result in rejected objections and payment responsibility for bills you intended to controvert and you should not be responsible in the first place. To avoid the headaches and being responsible for medical bills you should not be responsible in the first place, always check that you served to all proper parties. You must make sure that all people that they should receive that your denial are properly served and being put on notice. Our second recommendation is transition early. Start using the updated form now to avoid last minute errors and potential last minute adjustments. And always work with your counsel. If you're unsure about phrasing objections or certain level of MTG compliance, consult with your attorney before filing it. If an objection involves especially a complex MTG interpretation or certain level of legal argument that has to be raised, we strongly recommend to consult with your attorney before filing it. And always have a second pair of eyes, either by your supervisor, by another adjuster, or by legal counsel, just by someone to review whether the C-8.b and the objections you raised are board compliant. Taking just a few minutes for a careful review can save thousands of dollars by ensuring that the C-8.b includes all the information and explanation that the board now requires. Now, by staying organized, providing detailed explanations, and following proper notice procedures, you can successfully navigate the new C-8.b process and protect yourself from costly mistakes. Thank you for tuning in and see you next month.